Mr. Mpofu,
Thank you.
I'm really sorry to belabor this point, but
Yeah.
I'm confused about it.
Yes.
And perhaps in the meantime, you can ask your juniors to find in the papers the respondent's response to paragraphs 35, 36, 37, and 38 of the applicant's founding affidavit.
In this court?
Yes. And this is the question. You rely on 19.3b, and it says to stand for public office. It goes on to say, and if elected to hold office. If I understand your submissions correctly, you say that the authority or the powers of the Electoral Commission only extend to the first part of 19.3.
Of 19.3b, yes.
Now, this is my question, and it may seem like a very uninformed one.
Yes.
A person who stands for public office, if they are elected to the National Assembly, does it mean then when they are in the National Assembly, they are holding office?
That's a good question, Justice Theron. No. What it means is, there's this thing, the Americans call it president-elect. That's what you are called before you are sworn in. So you get voted in, and then you are known as the president.
Okay, let's cut to the chase. Once they voted in, are they holding office?
No, not yet. Until they are sworn in, they are not holding office.
So when they are sworn in, they're holding office?
Absolutely. That's why I think somewhere in the papers we call them MPs elect. So they are in that interregnum between the 30th of May, let's say, and the 14th of June. Everyone, including the president, by the way, is called the president-elect. Why? Because until the day that he is sworn in, he cannot be called the president. So similarly, those people, when they are in that twilight zone, they are, and I've made this up, members, MPs elect. And at the point of their swearing in, then they become members.
Let me follow up on that. Do you agree that if a candidate is not allowed to hold public office, they're also not allowed to stand for office?
No, I don't agree. Let me explain why. Because it is conceptually possible, Justice Theron, for someone, as I think I was responding to Justice Chick, for someone to be, let's call it objectively ineligible in March when those lists are put there. But their 5-year period is ending in April.
But Mr. Mpofu, we don't interpret legislation having regard to particular people's situations. We look at the legislation and we see what it means. Okay,
well, the answer is, the short answer then is yes, it is possible to be disqualified from standing for office, which is what 31A, but be qualified to hold office later. That's the answer.
So,
and vice versa.
At the time when you're disqualified to stand, when you're disqualified to hold office, at that time, say that's the election time.
Yes.
It also means that at that time, you're not qualified to stand for office.
No, it doesn't mean that. It means that the National Assembly, when it determines eligibility at some future date, that's why the word is used, and that's why I was making that point. It must determine at that point whether this person is disqualified or ineligible.
Do you have any authority for that submission?
No, well, it's the dictionary. Is means the present tense. So it means the...
Do you have any authority for the submission that at the time of the election, if the candidate is not qualified to hold office in the National Assembly, they are still qualified to stand in the election?
Yes, the authority is the law, Justice Theron. It's the section itself. Remember that that if this interpretation was correct, the one that you are posing to me, then it would mean that the job of the IEC would be to look at all the 15,000 people who are candidates, to determine all these things. But that is not the case, exactly because when the issue of eligibility comes, it's not going to be for 15,000 people, it's going to be for 400 people. And who are those 400 people? It will be the 400 people who, at that time, are vying to be MPs, for lack of a better word. So,
let's go to the first and second respondents' response to what is set out at paragraphs 35 to 38 of the founding affidavit. 35. What is the response and where do we find that, please, Mr. Mpofu?
Okay. I'm told, I think we made a qualification there that the responses would not be, is it 472? Yes.
Mr. Mpofu, right at the beginning of your address and more recently in discussion with my brother Majid, you asked where the IEC, what the basis was for the IEC decision, and you asked, did the IEC have any power to disqualify Mr. Zuma? Perhaps I can ask you to have a look at the record at page 246.
As
I understand the procedure, and we dealt with matters similar to this earlier in the week, the parties compile lists of their prospective candidates.
Section 471 is also very clear in that not only is it located in Chapter 4 of the Constitution, as opposed to Chapter 9, where the Electoral Commission is to be found, but refers specifically to eligibility for the membership of the National Assembly.
The Commission must decide the objection.
As if that were not enough.
In other words, it must decide is the objection good or bad, and must notify the objector and the party. It doesn't inform the candidate that the nominated candidate of the decision in the prescribed manner. And then subsection 4, the objector or the party who nominated the candidate may appeal against the decision of the Commission to the Electoral Court in the prescribed manner. Then sub 5, the Electoral Court must consider and decide the appeal and notify the parties.
Furthermore, the
power of the IEC to determine that the second respondent was disqualified is to be found in section 30 sub 3. The Commission must decide the objection. It decides the objection, it upholds the objection, and thereby it disqualifies the second.
Completely missed the crucial point that even ultra-virus objection does not concern whether Mr. Zuma was eligible or not for membership of the National Assembly, which is an issue for the merits. But the primary question of who is legally empowered, the power, empowered to determine that question, whatever the correct answer may be. So it's, in a nutshell, what we're saying there is that assume for present purposes that Mr. Zuma is not eligible. But if the body, the constitutional body that takes that decision is not one that is empowered to, then on that ground alone, the IEC would have strayed beyond its powers. Yes.
I would like to clarify the aspect of the directions that was sent by this court. The directions did not focus on the difference in the nature of proceedings. The question posed, the first question, was the effect of a conviction of civil contempt as opposed to criminal contempt.
Yes.
And the effect, that question must be answered with reference to our law. And in terms of our law, there is no distinction. Once the conviction takes place, there's no distinction after that. Before that, in the proceedings are different. But civil contempt is recognized in our law as an offense. Yes. And once a person has been declared or found guilty of civil contempt, that is a conviction.
Well, I don't agree with Justice Theron. That's what Justice Bilhitz was saying about which was considered correctly by one of my learned friends, that this distinction between so-called substantive and procedural rights is illusory at best. How can it be that the, let's call it, the mother of the conviction is in breach, let's say for argument's sake, of Section 35, but the child of that process is not. It cannot be, because Section 35, although...
Yes, I don't mean to interrupt you.
Okay, I'm sorry.
It may be difficult to accept, but that's our law, Mr. Mpofu.
No.
And that's what this court and the Supreme Court of Appeal in particular has said in decisions.
So, Justice Theron, please, if you can allow me to finish my response.
I'm sorry, please continue.
Thank you. I am saying that our law does make a distinction between a so-called civil contempt norm and a criminal accused. And the way that breach is, or rather, yes, that gap is breached is by what you suggested, Justice Theron, that the matter should be referred to the magistrate court or wherever, so that that gap is closed. Because then, if that had happened and Mr. Zuma was sentenced to 15 months, we wouldn't be here. Because who would come here and say it's not a conviction? But to argue that a civil contempt norm position in our law is the same as that of your run-of-the-mill criminal offender is wrong. That is why Justice Cameron posed that question in Faki, whether that person, in example A, can be said to have a previous conviction.
The effect of the decision of the Electoral Court is basically to nullify a decision of this court. And even though I may not agree with the contempt judgment, I'm not sure if a consequence that nullifies a decision of this court is something I can live with. And I'm speaking just for myself now.
Yes. No, that's a valid question. But as we discussed this morning, whatever the views might be out there, what the Electoral Court did was not to nullify this decision. So Mr. Zuma cannot now suddenly say, oh, well, the Electoral Court said for the purposes of Section 47(1)(e), I was wrongly convicted and therefore I'm going to claim from the state. No. That is what would have happened if the Electoral Court would have nullified. All the Electoral Court did was to ask a very simple question. Did the crafters of Section 47(1)(e), when they use the term convicted and sentenced, have in their contemplation the situation of Mr. Zuma, which we've repeatedly described? And our answer why that cannot be so, Justice Theron, is because we say, okay, I know the Constitution doesn't get drafted like that, but Section 35 had already defined those rights.
Let's assume I agree with you, Mr.
Yes.
Mpofu, that the drafters of Section 47 may not have had this scenario in mind or contemplated it, but we sit with the scenario.
Yes.
The one way to go is the way that the Electoral Court went, and to say it's not a conviction or a sentence for the purposes of 47.
Yes.
I have difficulty with that, as I put my first difficulty to you. The second difficulty with that, with the consequence of the decision of the Electoral Court, is that somebody who falls into the category of the substantive disqualification, the consequence of the decision of the Electoral Court is exonerated. There's no consequence. So that person is automatically excluded from the disqualification. And let me preface that by saying to you, as I said before, that the drafters didn't contemplate this, but this is the situation that we are sitting with. And perhaps this court, well, I'm speaking only for myself, maybe if we're forced to choose the lesser of the two evils, would it be to say, having regard to the majority judgment and the serious nature of the offence as articulated in that judgment, in this circumstance, it would be in the interest of justice that this court says, even though this may, and I'm only articulating my view, this may not have been a situation that had been contemplated by the drafters of Section 47(1), that here the proviso will not come into operation because of the final nature of the sentence handed down by the Constitutional Court.
I understand that. No, this court cannot do that. And I don't want to go back to the submissions I made in the recusal application, that this court might feel affronted by what the Electoral Court did. This court cannot do that because to do that would be really what we call double jeopardy. Because this court would now be saying for the second time, we're going to use a punitive provision against Mr. Zuma specifically, just because the Electoral Court did something that is wrong. But that's exactly what August, FF Plus, and all those cases says you cannot do. Because they're saying you must, if you are faced with that dilemma, you must decide in favor of enfranchisement, not disenfranchisement of Mr. Zuma. That's what those cases say you must do in that situation where there's really a choice to be made. It has to be done in the spirit of Section 19 of giving human rights rather than taking them away. So whenever, and we know, Justice Theron, that situation in all the relevant cases is postulated exactly for that. For a situation where it's not an easy choice, where it's 50-50, let me put it that way. And then it says that then the court must err on the side of enfranchisement rather than disenfranchisement. So this court cannot then want to punish Mr. Zuma, punish the MK party, punish all those people who may have wanted to vote for him, take away their Section 19 rights just to correct this. But secondly, and as I said to Justice Chikri, even if Justice, and that's why I'm saying this court has a way of not getting into all these things. Even if you are right, Justice Theron, and the solution is to say, look, we're going to err on the side of disenfranchisement, that still would be dealing with the first issue of the sentence, the definition of the sentence. But the issue of the remission cannot be answered in that way, because that issue, which could be the primary issue, is that's why I said to Justice Chikwe, assume there was not all these complications, and this was a straightforward sentence from a magistrate court of 2 years, and then there was remission where you take away 15 months, let's say, and it becomes 5 months, whatever the difference is, a 9 months sentence. At that point, if you accept the definition of remission, even if it was a normal sentence, you still cannot punish, because you still have to apply the section to favor enfranchisement. So you cannot then, on what basis could you say, yes, I know the sentence was reduced to 3 months, but for the interest of justice, we must disenfranchise Mr. Zuma?
The substantive disqualification in Section 47(1) does not refer to effective imprisonment or time served.
Yes.
It refers to the sentence imposed.
Yes.
And the imposition of sentence is a judicial function, as I understand it. There are authorities who have the power afterwards to shorten that sentence. There are authorities who can decide the minimum term of imprisonment. That's not what 47, as I read it, is asking. 47 is saying if you have been sentenced, and you're sentenced by a court. And I know this is two questions in one. My understanding is that there's a difference between pardon and between remission. Pardon expunges the record. Remission reduces your sentence.
Absolutely.
With the effect that you serve a shorter period. But the fact that you may have served a shorter period in prison due to early release on parole or due to a remission being granted, does that change the sentence imposed by the judiciary?
No, it doesn't. It does this, Justice. You see, the two problems with what you've just put to me. The first one is you use the word, if you have been sentenced, and that's wrong. The sentence, the Constitution deliberately says if you are at that particular point. So that's the first issue. The second issue is that remember what we're after here is what we call the purpose. Now, we are saying the purpose of the proviso is to ensure that, and my learned friends are quite correct, that the disqualification only kicks in when there is finality. True. But we are saying that finality cannot only be achieved by judicial means. In the normal course of events, that finality will be achieved by judicial means. But if that finality happens, remember when we say is, what is the situation today? If the finality we know now is that the sentence was reduced. So that's the finality. The mere fact that that finality has been brought about by the exercise of the prerogative powers, which supersedes in any event the judicial power, is neither here nor there. And that is why in the preamble of our heads we use this quotation from Sibiya. The executive can ordinarily alter the sentence of any convicted person after the judicial process has been completed. So that means that it is consistent with our Constitution that the executive alters, reduces, whatever the word is, a sentence of any convicted person after the judicial process is completed. The Constitution expressly empowers the President to pardon or reprieve offenders and to remit any fine, penalty, or forfeiture. It says that in one breath. There are provisions of legislation which empower the President to remit any sentence, to reduce, lessen, set aside, and to place people on parole and to unconditionally release convicted people from prison.
My last question, Mr. Mpofu.
Yes, thank you, Justice.
The respondents oppose the filing of a supplementary affidavit by the applicants. Do you persist in that opposition?
The filing of?
A supplementary affidavit.
I don't remember that.
So that means you don't, if there was, you don't persist in it anymore.
Did you find this? Oh yes, you're talking about in this court, yes. No, this is what we say, Justice. It's tied up really with what I call the preliminary points. You know, it's all very well for us to want to protect the integrity of this court. But we must protect the integrity of all our courts. So, this notion, which is really repugnant, that these parties are here to seek clarity. That's what they say. Firstly, it's disingenuous, because if they wanted to seek clarity, then we shouldn't be here on an urgent basis. It can be done at any other time.
Please can you address my question?
Yes, I am. And all I'm saying is that for anyone to say they are seeking clarity when the Electoral Court has granted that clarity is disrespectful and contemptuous of that court. Because that court, and I'm coming to the supplementary affidavit point, what necessitated the supplementary affidavit is the fact that the IEC jumped the gun and came to this court before the reasons were given. So they knew prophetically that these reasons will lack clarity. How did they know that? How did they know that the reasons will lack clarity by jumping to this court? They would never have been in a position to have to do a supplementary affidavit if they had simply waited for the reasons, read them, decide whether they are appealable, and then come here. So it is on that basis that we object to that, because it has made us, and I can tell you this, Justice Theron, we literally, by the time the reasons came out, we had sat day and night as a team, drafting the answering affidavit to that original affidavit. And then just as we were about to file it, the reasons came. So we had to throw all that into the dustbin and then deal with the reasons, which is what the IEC should have done. So my objection, a very strong one, is to the notion that they were able to predict that there will be no clarity. If they had accepted the outcome of the Electoral Court, there would have been clarity. Everyone would know the objection was, the appeal was dismissed. That's clarity. Why? What other clarity do they need?
Thank you, Mr. Mpofu.
That's good.
Thank you, Deputy Chief Justice.
Mr. Mpofu, thank you for your submissions. I realize you've been on your feet for a while.
That's fine.